Friends, good afternoon. This is Sohail Savani, the founder of the Savani Institute of Labor Laws and Skill Development, and a labor law advisor providing services across India. The primary goal of the Savani Institute is to bridge India's human capital gap by developing and accumulating vital skills and providing extensive and practical training on employment laws, which are now known as labor codes, as well as skill development within and amongst the Indian population. I would like to introduce and take this opportunity to greet all distinguished guests, officials from EPFO, fraternities from the consultancy field, and all registered participants, as well as, very importantly, none other than our Honorable Speaker, Advocate S.K. Gupta, who will address you all from his New Delhi office on the very important and critical issue of the Supreme Court's recent decision on employees' pension scheme. Thank you, Mr. Gupta, for accepting my invitation within short time. Mr. Gupta began his career by working for a well-known Indian manufacturing firms for almost 23 years. He has served enterprises as the HR head, working with personal, industrial relations, and legal functions. Mr. Gupta left his private sector career in 2003 to start his own labor law practice after being inspired by Mr. H.L. Kumar, Advocate Supreme Court and Chief Editor Labor Law Reporter. Mr. Gupta has been practicing in the Supreme Court and various high courts since then. Mr. Gupta also talks on the EPF, ESI, and labor courts at several national seminars held across the country. For efficient communication, today's session will be addressed in both English and Hindi. I'm aware that there are numerous questions in queue, such as how the matter began and made its way to the Supreme Court, how will the decision be carried out, how will the verdict affect EPF members drawing more than 15,000 per month, is a higher pension option available to normal PF members, can the Supreme Court's ruling compel the government to reconsider its decision on the Parliamentary Standing Committee on Labor's proposal for higher pension? I would also like to take this opportunity to inform everyone in the audience that, keeping the industry and its HR fraternities in mind, my flagship, Savani Institute, has launched a basket of professional certificate courses on the subject of labor and employment laws and codes, as well as various skill development programs in very simple and lucid language, with the noble cause of imparting training to freshers and working members with the latest technology and online governance mechanism. The Institute's panel of more than 50 prominent speakers was carefully selected from throughout India. I'm confident that everyone will get significant insights on the subject. With this, I wish you all the best and encourage you to provide feedback so that we can improve our processes and delivery. I would like to inform everyone that whatever questions you have, please leave them in the question box and I'll present before the speaker to get the answer. Thank you again. Over to Advocate Gupta ji. Gupta ji. Gupta ji.
Yes, sir.
Yes, sir.
कोई चक्कर होगा करना पड़ेगा
सर आपने दो डिवाइसेस से, हाँ, यस यस, नाउ यू कैन कनेक्ट सर. अनम्यूट कीजिए और आपका वीडियो ऑन कीजिए सर. Gupta ji, unmute yourself, sir. सर स्टॉप वीडियो करके जो गुप्ता जी।
यस सर।
हाँ, अभी आप अपना वीडियो स्टार्ट कीजिए। आप देखिए वहीं आपके पास ऑप्शन है।
देखिए सर, ऐसा है, वो ये मैसेज आ रहा है, यू कैन नॉट स्टार्ट योर वीडियो बिकॉज द होस्ट हैज स्टॉप्ड इट। अब अनम्यूट तो हो गया।
आप डिस्कनेक्ट करके वापस कनेक्ट कर सकते हैं।
तो दोबारा मैं डिस्कनेक्ट करूं फिर चालू करूं?
कर सकते हैं सर।
अच्छा ठीक है जी।
क्या हो गया सर? और तो एक ही होगा ना।
उनको होस्ट बनाना है क्या? वेट हेलो, हाँ वैसे हमें उनको होस्ट बनाना पड़ेगा तो वीडियो वाले।
क्यों?
हाँ
तो पार्टिसिपेंट्स को क्लिक करके मैं एक होस्ट कर दूं
हाँ।
मैं होस्ट कर दूं।
यस गुप्ता जी। गुप्ता जी unmute yourself. Yes. Yes sir. Screen is visible. Gupta ji, please start, sir. Thank you. सर आपकी आवाज नहीं आ रही है सर। Yes, yes. Now
Okay,
you
now?
are audible. Yes, please.
Okay, very good. Good afternoon, all the participants. I am SK Gupta. Today we are going to discuss in respect of the latest burning issue, that is in-depth understanding of the Supreme Court recent judgment on higher pension under the Employee Pension Scheme 95. Okay, so now we are going to start without wasting the time with this okay. When we have registered this program, there was a question among us. Okay, what is the ruling given by the Supreme Court on EPF pension scheme? Because there is a lot of print media news, there is a lot of social media news, and different views is coming across the country. But we will discuss what is the latest interpretation of this Supreme Court judgment. Why the Kerala High Court has set aside GS 609E, which was upheld, or you can say that earlier the Kerala High Court has set aside this notification, but now the Supreme Court by the latest judgment has already upheld. Okay. Who will be benefited by the latest Supreme Court judgment allowing pension, higher pension, and from which period? That is very important. Okay. How one can opt for the option under paragraph 11.3 and 11.4. That is important because these sections were discussed in the recent judgment and R.C. Gupta case also. Okay. How one can get a higher pension before retirement and after retirement too. Because actually, since from the last 1 week, we are getting a lot of question of the retiree, our senior citizen, that whether we will get the pension by this latest judgment and not. Just tell me. So I would also like to clear you under which circumstances the employee which got retired from before 1st September 2014 and after, we will let you know. What are the eligible conditions to get a higher pension? Because actually this all issue is related to the higher pension, not the statutory pension. Under Employee Pension Scheme 1995, read along with the latest new paragraph that was decided 609 notification dated 22nd August 2014, by which certain provisions were deleted and certain provisions were added. Okay. If the EPFO does not give higher pension, because actually after this judgment, even the previously the R.C. Gupta case was also pronounced in 2016, when the people they had approached to the EPFO, but some employee got a higher pension, but other was denied. Okay. So now what will happen if presently, if we are going to take an option of filing an option before the concerned RPFC or APFC, whether we will get the higher pension or not. If they refuse to grant the higher pension, what is the remedy available to our employee and retired person? Can an employee who has not given option but deposit his higher contribution more than 6,500 actual salary can avail the benefit? We will let you know at the end of this program, because actually we have designed this program for clarity and very, very simple language. Okay. Whether an employee who has not opted and also not deposited higher pension is a very important question. More than 6,500 actual salary can avail this benefit of higher pension. We will clear this all question, and somehow actually when we are going to present this PPT, then definitely I'm sure that 90% your question will be clear. Now, the contents of this PPT, brief discussion about the EPS and EPS scheme. Okay. What is the new amendments in the Employee Pension Scheme 2014? Because actually this provision has created a confusion and also curtails certain benefit of the employee. So that's why the employee approached before the Kerala High Court for questioning this 609E dated 22nd August 2014. Up now, this R.C. Gupta case is one of the good case, and that actually case has provided higher pension, or he has given a very good interpretation of paragraph 11.3. Okay. Now, another actually the latest case which has been decided by the Supreme Court on 4th November 2014. That case is Employee Provident Fund Organization and others, etc. versus Sunil Kumar and others. Okay. 2022 LLR 1318 Supreme Court. Now, after analyzing this all scheme and the interpretation of this both judgment, we are also coming on the conclusion findings of the case and question answer of all participants. Okay. Now, you're all knowing that under the Employee Provident Fund Act and miscellaneous provision, actually there is a 3 scheme has been legislated or made the applicable across the country. One is the Employee Provident Fund Scheme 1952, under which actually PF, whatever is deducted, that is very important. Kindly listen. That is called account number 1. Okay, I am going to refer this account number 1. Only that PF which is deducted from the employee salary, that is going in account number 1. And matching contribution which is given by the employer, that some percentage 8.33 will go to the account number 10. The pension account is called account number 10 and employee provident fund account is called account number 1. Okay. And second scheme actually employee deposit linked insurance scheme 1976. It is only insurance scheme. Okay. And third one, very important, for which actually this judgment came RC Gupta, and another is on 4th November 2014. That is Employee Pension Scheme 1995, which was replaced. That is a earlier Family Pension Scheme 1971 in November 1995. Okay, and another amendment came in September. Actually, basically, certain amendments was done, Employee Pension Scheme, which was disputed and various high court. Okay, so we will discuss this all scheme in this presentation. Now, Employee Provident Fund, what is the reason to legislate to give a retirement benefit? Okay, was brought force in the year November 1995 by replacing the Employee Pension Scheme 1971 to cater to the employee of the organized sector. The EPF Employee Provident Fund Scheme 1995 was made applicable to all employees who were covered under the Employee Provident Fund Miscellaneous Act. Okay. Thus, the member of the fund will receive pension on a permanent basis whole life, and the pension amount will eventually pass on to the family member upon the death of the employee. So it is a very good scheme for the private employee. Now, when this contribution is cutting, most of the participants, they are knowing that as per the section 6 of the EPF Act, that 12% PF is deducted from the employee basic salary. What basic salary? Which is defined under section 2B of the Act. Okay. So what percentage is deducted? 12%. Okay. So that 12% is going, kindly see in the bottom, that account number 1. Okay. Up now account number 10, which is the 10, that actually 12%. And out of 12, employer contribution. Kindly, again, I am repeating, employer contribution. So 12% out of that, 8.33 is going account number 10. That is a pension for which you are getting a pension, that amount. Okay. And out of 12, 3.67 is going to account number 1. I think actually it is clear to all my participants. Okay. Now, pension scheme, what actually amount is going to be deducted? That is very, very important. That basically in most of the organization, this pension only deducted up to the statutory limit, means either 6,500, earlier it was the 5,000, okay, then actually increased 6,500, and now from 1st September 2014, this limit is increased from 6,500 to 15,000. Okay. So what the minimum pension is deducted? If this slide as the dispute is prior to September 2014, that period of time, the statutory limit of the employee, it was 6,500, and the only pension fund is going, that is called 541 was deducted from your employer contribution. It was going to account number 10 maximum. Okay. Now, right now, this limit is 15,000. the maximum pension fund is being deducted from your salary every month, 1,250 rupees, and it is going account number 10, or it is going to deposit in the EPFO. Okay. Now, what benefit you are getting of this pension? Broadly, you're all knowing, but actually just I want to narrate in very brief that at the age of 50, you are getting a pension. Okay. The minimum service period for availing the benefit, because if you're going to start from today's service, then actually you have to cover 10 years for getting a pension. If you're not going to cover 10 years, less than 10 years, means 10 and half, that is, because more than half, it is called 10 years. Then you're not entitled to pension. Okay. Now, EPF contribution जो करता है, वो करता है 8.33 of the employee basic and DA. Okay. तो ये सारे एक्चुअली बेनिफिट है. आपको रिटायरमेंट की एज कितनी है? 58. जैसे ही आप 58 एज पे क्रॉस करेंगे, यू आर एंटाइटल्ड टू गेट द पेंशन. कम से कम एलिजिबिलिटी जो है, अगर आपको पेंशन प्राप्त करना है, तो यू हैव टू कंप्लीट इन द ऑर्गेनाइजेशन 10 इयर्स. ओके. आपका किस कंपोनेंट पे कटेगा? वो दैट इज ओनली द सैलरी व्हिच इज कमिंग अंडर सेक्शन 2B, that is called basic wages. So basic, DA and allowances made by the employer, it is going to deduct 8.33, but up to the statutory limit, means 15,000 या 6,500. And now actually form 10D can be filled, apply for a monthly pension on retirement. Suppose if you have left the organization and you do not want to continue the service, then actually what you can do, you can withdraw the money or you can EPS certificate. In case of death of the employee, the widow and the children get a monthly pension. Okay. The member can withdraw the amount if he has not completed 10 years. Okay. So these are the more or less is the benefit for the under the scheme. Now dispute started in respect of the higher pension in 2014 basically, and prior to also. Okay. So I'm going to cover how this dispute was started. So on 1st September 2014, what major change has been done by the central government, because they brought a new notification on 22nd August 2014, effective from 1st September. Okay. So what actually they have changed broadly, basically they have increased the limit from 6,500 to 15,000. And certain actually pensionable formula they have changed, and certain actually rider fixed by some months. So I will let you know in the next slide. Okay. Now this is the exact geo. Okay. 608 and 609. Okay. So now these are the 609E. Okay. By which what actually done that basically सैलरी की लिमिट चेंज की गई थी 6,500 से to 15,000. That is the one change. Another change ये हुआ था कि basically जो भी सैलरी है pension amount that will be calculated maximum to maximum on 15,000. Means higher provision जो उसका था वो 2014 में डिलीट कर दिया था. इससे अक्रॉस द कंट्री ये प्रॉब्लम आई थी हायर पेंशन की. फिर से रिपीट कर रहा हूं, ये GS 609 डेटेड 22nd अगस्त 2014 में मेजर जो चेंज किया, हायर पेंशन का प्रोविजन डिलीट कर दिया था. ठीक है. और ये ऐड किया कि मैक्सिमम सैलरी का जो कैलकुलेशन होगी वो अप टू 15,000 होगी. ठीक है. नाउ another change और किया था, which is very very important, let you know, 2014 से पहले अगर किसी भी एम्प्लॉय को रिटायरमेंट पे पेंशन मिलती थी तो उसका एवरेज 12 मंथ का होता था। फिर से रिपीट कर रहा हूं, अगर कोई भी कर्मचारी 2014 से पहले छोड़ा था तो उसको एक्चुअली जो एवरेज सैलरी काउंटिंग होती थी, पेंशनेबल सैलरी, वो 12 मंथ की होती थी। अब 12 मंथ से जो है 60 मंथ कर दी। दूसरा पेंशनेबल सैलरी में जिसको कि सुप्रीम कोर्ट ने करेक्ट या बोला है कि ये पेंशनेबल सैलरी का फार्मूला करेक्ट है, उसमें एक्चुअली प्रोरेटा बेस पर एक नया प्रोविजन ऐड कर दिया। वो क्या था कि आपकी पेंशन 95 से लेके अगस्त 2014 तक 6,500 के ऊपर ही कैलकुलेट होगी, और उसके बाद अगर आप कंटिन्यू करते हैं तो आपका जो पेंशन कैलकुलेशन है वह 1 सितंबर 2015 से 15,000 के ऊपर होगी। तो कैलकुलेशन एक्चुअली बेसिकली मोटे मोटे मैं आपको बताऊं 3 तरह की होती है। एक तो फैमिली पेंशन की जो कि प्राय 95 से होगी, और एक पेंशन का कैलकुलेशन होगा आपके 2014 तक, वो 6,500 के बेस पे होगा, एंड सब्सिक्वेंटली जो कैलकुलेशन होगा वो 15,000 के बेस पे हो। सो ये प्रोविजन दैट इज कॉल्ड प्रोरेटा, जो मैंने आपको रेड से दिखाया है, वो एक्चुअली बेसिकली वो है ये, ठीक है। अच्छा, नेक्स्ट एक्चुअली जो चेंज हुआ था, आप ये देखिए सी पैराग्राफ है, उसके नीचे लिखा है फॉर द वर्ड लेटर एंड फिगर ₹6,000 word change be substituted. Now what actually every time they say that actually it is going to change. Okay. Now अब हम एक्चुअली इसको ब्रीफ में देखते हैं, क्योंकि नोटिफिकेशन वो जो लीगल होता है उसको पढ़ने में थोड़ा सा दिक्कत आती है, लेकिन अगर एट ए ग्लांस हम देखें कि क्या क्या स्कीम में चेंज हुआ था वो हाईलाइट बता रहे। एक तो सबसे पहले जो लिमिट चेंज हुई, लिमिट कौन सी चेंज हुई? 6,500 से 15,000। कब से हुई? 1 सितंबर 2014 से, ठीक है ना। कैलकुलेशन जो पेंशन का पेंशनेबल सर्विस काउंट की जाएगी, ठीक है ना, जो सैलरी होगी वो एवरेज जो है 12 मंथ का ना लेके अब 60 मंथ का लिया जाएगा। तीसरा चेंज हुआ था, तीसरा चेंज ये हुआ था कि 1.16% ओवर एंड अबव द 15,000, ठीक है ना, दैट विल बी बोर्न बाय द एम्प्लॉय। इसको मैं दोबारा से आपको समझाता हूं। यदि कोई भी कर्मचारी का हायर पेंशन का इशू है और उसकी हायर पेंशन डिडक्शन होती है तो 6,500 या 15,000, तो 15,000 के बाद जो 1.16% जो कि सेंट्रल गवर्नमेंट देती है वो अब कर्मचारी को देना होगा। ये चेंज हुआ तीसरा। चौथा चेंज हुआ, हायर पेंशन का जो प्रोविजो है वो डिलीट कर दिया, वेरी डैमेजिंग टू द एम्प्लॉय। तो डैमेजिंग एक्चुअली बेसिकली दो हैं, 1.16 इतना डैमेजिंग नहीं है। डैमेजिंग है सबसे बड़ा जो है वो 12 मंथ के एवरेज से 60 मंथ का करना और हायर पेंशन का प्रोविजन को डिलीट करना। पांचवा पॉइंट उन्होंने किया कि अब जो है किसी भी हालत में 1 सितंबर के बाद यदि कोई भी नया कर्मचारी ज्वाइन करता है तो उसका हायर पेंशन का तो प्रोविजन डिलीट कर दिया। तो अब उसका जो कैलकुलेशन होगी पेंशन की वो 15,000 पे ही होगी, ठीक है ना। कैलकुलेशन ऑफ पेंशन प्रायर टू 1 सितंबर 2000 सब्जेक्ट टू मैक्सिमम 6,000 पर मंथ and for the period thereafter at the maximum. Okay, this is pro rata, मतलब 2014 से पहले 6,500 और 2014 के बाद जो है वो 15,000 पे कैलकुलेशन होगी। सेवेंथ एक्चुअली इट इज वेरी इंपॉर्टेंट, व्हाट हैपेंड कि बेसिकली जब ये प्रोविजन आया था सितंबर 2014 में, तो एक राइडर फिक्स किया गया था इस नोटिफिकेशन में कि जो एग्जिस्टिंग ऑलरेडी हायर पेंशन ले रहे हैं या लेने के इच्छुक हैं उनको 6 महीने का टाइम दिया जाता है, वह अपनी एप्लीकेशन एपीएफसी की ना फाइल करें। दैट इज कॉल्ड ऑप्शन, that option under paragraph 11.3, 11.4. Okay. Again, I am repeating, this option under the scheme is available under paragraph 11.3 and 11.4. अब हुआ क्या कि ये कम्युनिकेशन मोस्ट एम्प्लॉय के पास नहीं पहुंच पाई और एक साल गुजर गया, मींस 30 अगस्त 2015 के बाद यदि किसी भी एम्प्लॉय ने ये ऑप्शन फ्रेश नहीं दिया है तो इट विल बी डीम्ड दैट ही हैज नॉट ऑप्टेड फॉर हायर पेंशन. दैट इज द सेकंड इशू. अब ये नीचे जो बॉटम पे है ये बहुत इंपॉर्टेंट है. ऑलमोस्ट हमारे जो लर्नेड पीएफ कंसल्टेंट हैं, ईएसआई के हैं या जो एडवोकेट हैं लर्नेड, वो जानते हैं. नॉर्मली एक्चुअली एम्प्लॉय को ये बात नहीं मालूम है कि अब सितंबर 2014 के बाद 1 सितंबर में अगर किसी फ्रेश कर्मचारी ने ज्वाइन किया है किसी कंपनी को तो उसको हायर पेंशन नहीं मिलेगी. और यदि उसकी सैलरी ज्यादा है तो सबसे पहले उसको ऑप्शन जो है पेंशन से पहले 26(6) में ईपीएस स्कीम में लेना पड़ेगा कि मेरा एक्चुअली फंड काटा जाए 15,000 से ज्यादा सैलरी पर, तो एक ऑप्शन देगा. और 26(6) में एक बहुत इंपॉर्टेंट प्रोविजन है कि जब तक एम्प्लॉयर नहीं चाहे आपका ना तो हायर पेंशन मिल सकती है ना ही हायर पीएफ मिल सकता है. गवर्नमेंट इसमें कुछ भी नहीं कर सकती. सपोज करो आपने 15,000 से ज्यादा पे किसी ऑर्गेनाइजेशन में ज्वाइन किया है और आप ये चाहते हैं कि मेरा पेंशन और पीएफ 15,000 से ज्यादा कटे, तो सबसे पहले कंसेंट जो है वो एम्प्लॉयर की होगी. दिस इज ए प्री कंडीशन. अगर एम्प्लॉयर नहीं चाहता है तो यू कैन नॉट अप्रोच टू एनी पर्सन, एनी कोर्ट that I am entitled to get a higher pension. मेरे को हायर पेंशन मिलनी चाहिए, मेरा एम्प्लॉयर नहीं दे रहा है. No, because 26 is very clear. Okay, because he has to deduct first liability going to increase. 15,000 से ऊपर पे पीएफ काटेगा, फिर उतना ही मैचिंग उसको जमा करना पड़ेगा. साथ में बहुत इंपॉर्टेंट है एडमिनिस्ट्रेटिव चार्ज भी एम्प्लॉयर को 1 जो कि अब 55.55 है, पहले वो 110 था. ओके, तो एक्चुअली नए एक्सक्लूडेड एम्प्लॉय ईपीएफ के मेंबर तो हो सकते हैं लेकिन पेंशन के मेंबर नहीं हो पाएंगे. फिर से मैं रिपीट कर रहा हूं, अगर 26(6) में एक्सक्लूडेड एम्प्लॉय ने ऑप्शन दे दी है, एम्प्लॉयर ने उसको मान लिया है और एपीएफसी ने भी मान लिया है, लेकिन पेंशन फंड नहीं कटेगा उसका. इट मींस दोनों शेयर जो है 12% अकाउंट नंबर 1 में जाएंगे, अकाउंट नंबर 10 में नहीं जाएंगे. दिस इज द प्रोविजन विच वाज अमेंडेड फ्रॉम सितंबर. और इस नोटिफिकेशन को सुप्रीम कोर्ट ने वैलिड करार दिया है. सर्टेन राइडर, 2 राइडर लगाए हैं, वो मैं आपको बताऊंगा. बाकी अदरवाइज ये जितना मैं आपको दिखा रहा हूं ये सब कंफर्म किया है सुप्रीम कोर्ट में. And there is no other higher court other than Supreme Court. ठीक है. अब मैं आपको कंपैरिजन से बताता हूं क्या क्या चेंज हुआ था. देखिए, पैरा नंबर 11(1) चेंज हुआ. चेंज में क्या था, पहले 12 मंथ का था, अब उन्होंने 60 मंथ कर दिया एंड साथ में सर्टेन राइडर भी लगाए. एक मेजर चेंज किया. दूसरा 11(3) में जो चेंज किया था ये बहुत इंपॉर्टेंट है. मोस्ट ऑफ द एम्प्लॉय को मालूम होगा, लेकिन नहीं मालूम है तो ध्यान से देखिए डिस्प्यूट क्या था. बिकॉज हम लोग डिस्कस तो करते हैं कि भाई वो हायर पेंशन का इशू चल रहा है, लेकिन मैं आपको बताऊं हायर पेंशन का इशू नहीं चल रहा है. हायर पेंशन का प्रोविजन था स्कीम में, वो जो रेड में है आप पढ़िए सर, ये लिखा हुआ है क्लियर. प्रोवाइडेड दैट if at the option of the employer an employee contribution paid on the salary exceeding 6,500 per month from the date of commencement of this scheme or from the date of salary exceeds 6,500, whichever is latter, 8.33 share of the employer thereof is remitted into pension fund and pensionable salary will be based on higher salary. Means अगर उसका 6,500 से ज्यादा पर पेंशन कट गया है तो वो हायर पेंशन का अधिकारी होगा। तो ये जो रेड पोर्शन आप देख रहे हैं इस साइड में, इसको डिलीट कर दिया, इसलिए मैंने राइट साइड में लिखा है कि हायर प्रोविजंस डिलीटेड, मेन रीजन फॉर डिस्प्यूट यही था। ठीक है सर। अब 11.4 क्या ऐड किया, क्योंकि ये दोनों सेक्शन के बारे में जजमेंट में बहुत अच्छी तरीके से बात किया है, क्योंकि उसने रिपीटेड लिखा है 10.3, 10.4, वो 11.3, 11.4। अब 11.4 क्या है? 11.4 ये है कि एग्जिस्टिंग मेंबर एज ऑन 1 September 2040 who at the option of the employer and employee had been contributing exceeding 6,500. Why I'm क्योंकि ये जो डिस्प्यूट है वो बिफोर सितंबर पे है, तब एक्चुअली 6,500 रुपए थी। May on a fresh option to be exercised jointly by the employer and employee continue to contribute on the salary exceeding 15,000 per month, and the pensionable salary for the existing member who prefers such fresh option shall be based on the higher salary. It means अगर किसी भी कर्मचारी ने इस नोटिफिकेशन के आने के बाद 11.4 एक साल के अंदर ऑप्शन नहीं दी है, तो वो दे आर नॉट एंटाइटल्ड, यही डिस्प्यूट चल रहा था। एंड फ्रेश ऑप्शन का टाइम क्या था? 6 महीने प्लस 6 मंथ। ठीक है ना। तो ये बेसिकली मैंने कंपैरिजन की एक एक्चुअली आपको स्लाइड बनाई है। नेक्स्ट, अब ये मैंने थोड़ा सा ब्रीफ में, जैसे एक कहते हैं ना क्या, छोटा सा आप दिखा दीजिए हमको क्या क्या चेंज हुआ है। जैसे आप सपोज करो इफ यू आर गोइंग टू डिस्कस दिस मैटर विद योर डायरेक्टर और द सीनियर बॉस, तो वो एक्चुअली ये स्लाइड देखने के लिए है, तो आप ये स्लाइड उनको प्रिंट आउट लेके कि सर ये डिस्प्यूट था। अब डिस्प्यूट क्या था? 12 मंथ को 60 मंथ कर लिया है। मैं रिपीट कर रहा हूं आपको, जिससे कि आपके दिमाग में या माइंड में ये चीज बैठ जाए। और एम्प्लॉय में कंट्रीब्यूट हायर पेंशन, ये हायर पेंशन का जो प्रोविजन था 95 में नहीं था, ये बेसिकली 96 में ऐड किया है गवर्नमेंट ने ये प्रोविजन। ठीक है ना। तो हायर पेंशन का इश्यू ये नहीं है कि 2014 में डिलीट किया या 2014 में ही आया, ये बेसिकली हायर पेंशन का जो इश्यू था वो एक्चुअली इश्यू नहीं, ये प्रोविजन जो है 96 में ऑलरेडी ऐड कर चुके। कैलकुलेशन ऑफ पेंशन एवरेज 12 महीने की है और 1.1। Am I audible to all?
Yes. Gupta ji, sorry for interrupting. Please use English more often, sir.
Acha, English more often. Okay.
Yes.
Now, the dispute of the higher pension, if you are going to discuss with your senior boss, employer, so definitely they will say, what is the, in brief, you just tell me. So you can show this slide and tell them that actually first dispute or the first benefit was curtailed from the employee, that 12-month average salary was now changed 60-month average. Okay. Now actually the pensionable salary will be calculated on the basis of the pro rata basis, means the 6,500 salary average will be calculated up to August 2014, and from September 2014 the pensionable salary will be calculated based on 15,000. Now, before 2014, there was a specific provision in the scheme which was inserted in 1996. So I can say that there was a already higher pension provision in the scheme. Okay. Now in 2014, that was deleted. I have written higher salary paragraph deleted. Okay. Calculation of average 12 month. Okay. And 1.16% over and above, that will be borne by the employee. Now condition, they have again some rider has been fixed by the fresh option will be given by the 6 month, another 6 month with filing a delay condonation application, and over and above 15,000, 1.16% will be. So most of the employee could not exercise for the higher pension. This is the only dispute. So this relief has been granted by the Supreme Court. So I can say this all judgment in favor of the employee as well as the EPFO. I will let you know how I'm saying win and win situation. Okay. Now, basically, I think you have all understood the what was the scheme and what was the dispute before the Supreme Court. Now let us discuss the higher pension issue and also discuss the following important decided case, R.C. Gupta. In R.C. Gupta case, I was also counsel in this matter on behalf of respondent number 2. Okay. So I am knowing this each and everything, what argument has given by the EPFO and what argument was placed before the Supreme Court. Okay. And second, actually, P. Shashi Kumar and others, this is also very important because when this R.C. Gupta case was going on before in the Supreme Court, that period of time, because this R.C. Gupta was decided in 2016. Okay. Now, and 2014 there was a notification. So notification again challenged before the Kerala High Court. Many retired employee, existing employer association, they have challenged, and the Kerala High Court said no, this notification arbitrary because there was a provision and the employee were enjoying the higher pension, this benefit, and they were also enjoying this 12 months. So all provision is wrong. So he has quashed that 609E notification. Against that notification, the EPFO filed before the Supreme Court SLP, but SLP also dismissed on 1st April 2019. Okay. Then the EPFO filed a review petition against this, and Union of India also filed a writ petition because Union of India is also affected. Only 1 point, because actually he is not a person to go before the Supreme Court because he was not a party at any stage. Why actually Union of India, the central government, gone before the Supreme Court? Because 1.16%, which also being contributed by the central government from the consolidated fund, means government money. Okay. So now actually Union of India has filed and EPFO has filed the review application. That review was allowed, and when this matter came before the double bench, they also say that this matter has to be referred to the larger bench. When this matter was referred to the larger bench, and 3 judges, they have decided this matter. Okay. So now we are going to discuss only 3 cases. Now, R.C. Gupta case. Basically, this case was decided, Justice Rajan Gogoi, Honorable Mr. Praful C. Pant have decided this matter on 4th October 2014. This R.C. Gupta was decided October 2 by giving a relief higher pension to R.C. Gupta as per paragraph 11.3, which I have narrated. Okay. And also gave interpretation of 11.3 because that period of time केवल 11.3 का ही था, 11.4 नहीं था. It was added only after 2014. Okay. So now actually this all things were decided in favor of R.C. Gupta case. Now, what was the dispute of R.C. Gupta? I have written in the brief. What is it? R.C. Gupta was retired in 2005 and took the plea that the provision brought in by the amendments of 1996, which I have narrated, was within his knowledge, and he should be granted higher pension benefit because the employer contribution was deducted on actual salary. That actual salary is very important for this higher pension issue. Okay. Why I am saying Mr. R.C. Gupta was drawing salary more than 5,000 or 6,500. So, uska jo PF tha, it was deducted on more than 5,000 and 6,000 salary. It means that is called actual salary. Okay. When the actual salary PF was deducted, so he was deemed to entitle higher pension. Okay, na? Ab now this case was discussed. Okay, na? And 3 principle was decided by the Supreme Court in respect of this R.C. Gupta case. What his case? If both the employer and employee has deducted PF on actual salary, the word used actual means more than 6,500. Okay, not the ceiling limit. What is the ceiling limit? 6,500. Means actually RC Gupta ka jo salary tha, it was deducted on more than 5,000 or 6,500. Exercise of option under paragraph 26 of the provision is inevitable. Okay, I have written in Hindi also. जिसे घटित होने से रोका ना जा सके अवश्य होने वाला. It means actually there is no precondition under section 26(6) that until unless he has given a option before the assistant provident fund commissioner, he cannot go for higher pension. This was the objection, but they have ruled out. So the first principle 100% in our favor. Okay, and second exercise of the option under paragraph 26 is not precondition to exercise the option under 11(3). Means यदि एम्प्लॉयर उसकी सैलरी पर टोटल पे पीएफ काट रहा है तो ये समझा जाएगा डायरेक्टली इनडायरेक्टली कि एम्प्लॉयर की कंसेंट है, एम्प्लॉय की कंसेंट है और उसने 11(3) में हायर का प्रोविजन दे दिया है. तीसरा बहुत इंपॉर्टेंट है that no cut off date to exercise option under 11(3) because there was no cut off date before 2014. Cut off date was legislated in GS 609 6+6 month, and that was option was given one time only. Okay, so there was no cut off date. It means employee anytime can opt 11(3) because there is no rider fixed by the legislature while making this scheme. So three principle has been made by and this is all in benefit of the employee. Now these are the full judgment I have made summarize. Okay, para 10 of the RC Gupta is very important. We do not see that how exercise option under paragraph 26 of the Provident Fund can be constructed to stop the employee from exercising a similar option under paragraph 11(3). If both the employer and employee opt the deposit against the actual salary, not the ceiling, the word is very, very forcefully they have written against the actual salary, not the ceiling, means there was an option, there was a reason that actually he should be granted a higher pension. The above part in a situation where the deposit of the employer share 12% has been on actual salary, not the ceiling. We do not see how the Provident Fund Commissioner, because RC Gupta won this case before the single judge. Okay, so now there was an observation that we do not see how the Provident Fund Authority could have been aggrieved to file a LPA. Means actually when the single judge has decided, they should not go for the LPA before the division bench of the High Court. All that the Provident Fund Commissioner is required to do so. There is a direction in case of adjustment of the account. What is the adjustment of account? Means if you have deducted the on actual salary and put the all funds in account number 1, you can transfer from fund account number 1 to 10 automatically. Okay, so this is also direction in the RC Gupta case. Consequently, in the light of above, we allow this appeal and set aside the order of the division bench. Means Himachal Pradesh High Court ka DV ka judgment they have set aside. So RC Gupta, I can say it is totally not in favor of the employee, but in favor of the legislation, because whatever the law made by the parliament or the central government, on the basis this judgment was decided by the Supreme Court, no favor has been done by the Supreme Court, either EPFO or RC Gupta. It was totally based on the legal provision of law. Okay. Now, P. Shiv Kumar actually directly, indirectly, what happened? Actually, this case was going on. In the meantime, this 22nd August 2014 is brought by the central government, and it was challenged. Okay, when it was challenged, then what actually is Kerala High Court ke all consequential orders and proceeding, because actually when this notification came, all the higher pension issue this was stopped by the EPFO. Okay, that's why actually this matter has gone before the first Kerala. All consequential order proceedings issued by the PF authority on the basis of the impugn amendments. Okay, because they say no, our provision say that your PF is being deducted or calculated on only 6,500 or 15,000. We will calculate like that. So all proceedings when started by the EPFO, that was quashed. The various proceedings issued by the EPFO declining to grant opportunity. Actually, because 1 year has already been expired. So they have declined all the employee. We are not going to grant the opportunity to exercise joint option. Joint option 26(6) of the scheme 1952 and under 11(3). But actually there is no provision like 26(6). This was discussed in R.C. Gupta. That is called interpretation. Okay. That's why actually R.C. Gupta case will clearly say there is no precondition. Okay. 11(3). That actually if he has not accepted or he has not filed any application 26(6), then he cannot opt 11(3). No, it is not like that. If the provident fund has been deducted on actual salary more than ceiling limit, then it will be treated that option has been given by the employee. This is the interpretation given by the R.C. Gupta. Now, third one, the employee shall be entitled to exercise the option stipulated by paragraph 26C scheme without being restricted in doing so by the insistence of date, because that 609 has made a rider that after expiry of 1 year, you cannot exercise. Okay. So that all things has been set aside, and against that actually the EPFO has gone before the Supreme Court SLP, but SLP was dismissed. Then they filed the review application, and simultaneously Union of India also filed a writ against. Okay, so this is the again actually judgment. The Employee Provident Fund organization, Sunil Kumar B and others, SLP civil like that, and reported in 22nd LLR 131C Supreme Court. Now, against major actually that three judgments. First judgment is in respect of this Kerala High Court, and second is decided by the Delhi High Court, and third one is decided by the Rajasthan High Court. Again, these are from employee directly, individual, and the association. There was a bunch of writ petition and SLP, which was joined and decided on 4th November. Now, I am coming very important issue to discuss, because sometimes actually I am listening from a lot of people that it is, I say there is no confusion, sir. I say again, very, very clear judgment. It is only our what on which eye we are looking this judgment, because we have to see this judgment from the angle of the judges, okay, not from the general public. Now, first option, I say has gone in favor of the employee. Actually, I am saying 609E was subject to two modifications, which was required in favor of the employee. Okay. Otherwise, only the pensionable provision, and rather I can say 60 months, that was declared valid. Otherwise, two provision which are opportunity, just say earlier it was a 1 month, up now the Supreme Court has granted to all employees. So I can say, please, if the employer is going to attend this program, they should encourage to the employee to submit the option. I have designed 2 forms. I will let you know and show you on this program. Okay. And second, actually 1.16, which is being asked to remit over and above the 15,000. So that been declared ultra virus. Okay. So now central government or the EPFO will bring certain this provision that was also direction. So this is the first direction. I think my participant, they have clear. Second direction is very, very clear. What is going on when this RC Gupta came, this case came, then actually employee is going before the EPFO for exercising an option as per the new notification or as per the RC Gupta. Then actually RPFC, APFC, they have again confused the or denied the legal right of the employee by saying, no, I will give only this higher pension benefit to the unexempted establishment. What is the unexempted establishment? Those establishments where the account number 10 and account number 1 both provident fund is going to deposit. Actually हमारे like government के जो organization है, it's a big private organization, they are having a exempted establishment under section 17 of the PF Act. So what actually they have denied, नहीं हम तो अपना account number 1 से 10 में transfer कर सकते हैं, but we will not take money from the unexempted establishment. So that actually clear. By this judgment, the second dispute has been made very clear. They say no, exempted and exempted both are equal, because exempted establishment is also under control of the EPFO. So that was the wrong intention or wrong decision of the EPFO. Okay, so I think this second, who had exercised option under Proviso 11(3) of 95 scheme and continued to be in service on 1st September 2014 will be guided by amended provision, means 11(4). What will happen? I advise to all employees who could not exercise their right for higher pension and they are still continuing in service. This benefit is available another 4 months. So I advise to all existing employee, it is a good opportunity to go for higher pension. Okay, so this is the third. And the fourth one, again very important, what is going on? The provision 11(3) of the pension scheme as it was before the 2014 amendment से would be entitled to exercise option. Means actually basically इसका clear शब्दों में ये कहना है कि that proviso to paragraph 11(3) of the pension as it was before the 2014 amendment would be entitled to exercise option under 11(4) of the post amendment scheme, and their right to exercise option from 1st September stand crystallized in the judgment of RC Gupta case. मतलब इसका total I am saying that the RC Gupta case and the interpretation 11(3) was again upheld, reconfirmed, and directed that everybody has to accept again in favor of the employee. There is no adverse benefit which is not given by the Supreme Court to the employee. Now, so I think this 4 point has been understood by all my dear participants. Next, this fifth is very important because actually most of the question I am getting from this only. So you just read the red portion. Why I am saying the employee who had retired prior to 1st September 2014 without exercising, means if their salary was not deducted prior to 2014 and they have retired, I say entitled to get the higher pension. Again, listen me. वो कर्मचारी फंड एक्चुअल सैलरी पे करता था 1 सितंबर 2014 से और वो रिटायर हो चुके हैं, वो भी इस स्कीम के या इस जजमेंट के हकदार होंगे. ठीक है ना, क्योंकि जो शब्द लिखा है दैट इज वेरी, without exercising कौन सी है? Means उनका actually they have not exercised, the PF was deducted of those employees up to 6,500. ठीक है ना? So then employee actually he is not entitled, because right now if he is going to say that I want to be given a higher pension, the employer may refuse. Why actually employer is going to refuse? The consent for higher pension first from the employer will come. Employer अगर उसको higher pension का exercise option दे देगा, तो what will happen? The employer damage भी देना पड़ेगा और उसको interest भी देना पड़ेगा as per the section 14 and interest as per the section 7Q, because when the employer is going to remit the बैलर ऑलरेडी वो एक्सरसाइज कर चुका है, तो उसका तो ऑलरेडी फंड अकाउंट नंबर 1 में जमा था. ओके, तो दैट इज सब लिखा है विदाउट एक्सरसाइजिंग. तो दैट इज आई थिंक you have understood my version in respect of this 5th direction. And 6th direction है the employee who have retired before first upon exercising option. ये उसका opposite है, that this direction. ये कहता है अगर you were exercising upon 11/3, you have already exercised, means आपका actual salary पे provident fund करता था, तो then actually that employee will be covered and the opportunity is given to file a option. Okay, उसको actually basically option देना पड़ेगा. ठीक है. अब 7th में actually क्या है? 1.16% of their salary to be extend such salary exceed 15,000 per month as an additional contribution under the amended held to be ultra virus, means 1.16%, which is going to be charged from the employee over and above 15,000 that has been treated as ultra virus. For that actually this is red में जो लिखा है मैंने, it is very important. Operation of this part of this order will remain suspended for a 6 months. Means actually क्योंकि आपको जो retired आदमियों को जो time मिला है वो that is a 4 month, and the implementation of RC Gupta is given a 8 weeks. It means 1.16%. It has suspended another 6 months, but means actually if you are going to retire in this period or prior to date, you have to pay 1.16% of your over and above, because this operation has been suspended for 6 months. It means employee is liable to pay this amount. Okay, after expiry of 6 months, this provision will be replaced by any other ordinance or any other provision of law. Okay, now 8th में no law for computation of the pensionable service. So by actually I am saying only the 2 major rider has been fixed. 12 months to convert into 60 months. Okay, average salary. One of the right they have found calculation, means prior to 1 September 2014, the calculation will be done up to 6,500 and thereafter 15,000. So actually I say there is no flaw for computation of pensionable service. So they have held this 609 pensionable provision valid. Now again actually it is very important. So actually I have made this separate slide. The last direction, just read, beautiful direction and totally in favor of the employee. RC Gupta so far as interpretation of the provision to paragraph 11(3) pre-amendment pension scheme is concerned, the fund authority should implement. You see the direction, forceful direction has been given by the Supreme Court by saying that the fund authority shall implement the directive contained in the said judgment within a period of कितने दिन में? 8 वीक में. It means जिन कर्मचारी 2014 से पहले एक्चुअल सैलरी पे पीएफ कटता था, वो सारे कर्मचारी को बेनिफिट मिल चुका है और 8 वीक के अंदर ईपीएफओ आपको हायर पेंशन का बेनिफिट देना पड़ेगा. This is the direction. Again I am reading. The PF authority shall implement the directives contained in the said judgment within a period of 8 weeks. subject to our direction contained earlier in this paragraph. What is that paragraph? The contempt application which was filed by the different employee for non-compliance of the R.C. Gupta case are not accepting the higher pension, that will be disposed of. If it is not followed, the contempt application will be revived. Very important. So this direction is very, very important in favor of the employee, and all the employee will get a higher pension. This is my actually interpretation, and my interpretation based on the judgment of the Supreme Court. Okay. Next, what is the exact direction which I have given this word by word? That is provision 609. It is legally held, and this is the all detailed. Okay, there is no need to wastage of time because I have already given that exposure and with interpretation and example. So this is the total judgment of the EPFO. जो ऑपरेटिंग पार्ट जो सबसे लास्ट में दिया जाता है, जो कि एक्चुअली एक डायरेक्शन में, एंड ब्यूटीफुल ड्राफ्टेड, ब्यूटीफुल वर्डिंग, nothing, no ambiguity has been given in this judgment. Okay, now some important point I am going to tell, which is the most of the employees they are knowing, but I want to repeat. For 9 months and 6 months more will be treated as a 10 years. Means every 6 months and more will be treated as a 1 year in all calculation. Okay, lifelong pension after the retirement till last breath, you will get this higher pension. Okay, a employee can start receiving the pension at least minimum 10 years, which I have narrated in the beginning slide, and the minimum age to start the pension is 50, but there is a reduction. I will let you know next time how this amount is going to reduce. But at the age of 58, you are entitled full pension. Okay, no pension is payable before the 50 years. Early pension can be claimed after 50 years, but before the age of 58. But it is subject to discounting factor 4%. Okay. The maximum pension per month is subject to 3,250 rupees minimum. Okay. On 6,500, if the statutory limit is 15,000, then the pension will be 7,500 per month. Minimum pension, if it is coming less than 1,000, the minimum pension will be given 1,000. And maximum service is very important, is 32. Okay. And however, if any employee is going to complete 20 years or 22 years, then 2 years will be added as a bonus. But maximum salary will be counted, but maximum year of service is counted is 35. Suppose if I have worked in the company in 35 years, my 2-year bonus will not be added. The total 35 will be counted. No pension can receive more than one pension, because actually there is a break in service. One person is working X employer, then by he is getting it, he has completed 10 years, then he is getting some pension there. So no, it can be cashed now anytime. Earlier it was, but now it is not possible. So that was rider has been fixed by the government that one pension will be given only for one employee. Now I am coming for the calculation. Okay, calculation. I have very simple formula that current EPF 15,000 ceiling salary. This is only for the minimum or statutory pensionable service into 70. Example 15,000, 35 and 70. That minimum maximum pension is 7,000. And the same calculation I am going to do in higher pension. You just see what benefits employee will get, and more attraction will come in the private sector, because after 1 lakh rupees, if a person is working 35 years, how much amount will be given? 50,000. Very attractive. He will not depend on the return, and he will enjoy retired life like a government employee. Right now, if a person is getting a 7,500 after doing a 35 years or 30 years service in the private sector, and he is getting a maximum pension 700 7,500. That is a cost, even not a for medicine value. Okay, 7,500 में आज की डेट में एक रिटायर्ड आदमी हस्बैंड वाइफ को कुछ भी नहीं होता है, ठीक है ना, नथिंग, 250 रुपए पर डे, इज अ वेरी स्मॉल अमाउंट. सो आई कैन से हायर पेंशन जो है, दैट इशू decided by the Supreme Court, it is really marvelous and good for the private sector employee. Now I have made a comparison के 6 months से और 12 months से कितना लॉस होता है, but now actually this scheme has been held valid by the Supreme Court. Now I can't say, you just imagine अगर मेरे को 15,000 रुपए सैलरी है और 35 साल की सर्विस है, 7,500 मिलेगा, और 50,000 की है, 12 महीने का एवरेज है 35 के हिसाब से सेम है, तो मेरा जो पेंशन आएगी 25,000. If my pension is going to be calculated on 12-month average, then I will get 25,000, and the same new amendment is coming, then I will get 30,21,10. मतलब 4,000 का मेरे को सीधा सीधा ये लॉस है नए जियो से 609E. So this is a loss, but I have to bear this loss. At least actually after doing a service of 35 years and I have left this any organization, then at least 21,000 I will get. It is a reasonable amount to live properly without depending upon the children. Okay, now this is the reducing salary. Suppose karo if you want to take a pension at 50 age, so 7.78% it will be reduced. These are the factor. According to that factor, your pension will be reduced. This is a table. Now I am coming very good question and good actually calculation. Actually you will not get this calculation in any book or anywhere. I have made this just to show with the proof of mathematical calculation. Now you just say, if I have worked 33 years, 2 years bonus, then I will get a 7,500. So now this factor is coming to 2 से 15, 2 से 14, 2 से 14, 2 से 14, 2 से 15. So it means actually I have proved that 214 is the factor. You can calculate anytime. You do not know the क्या calculation है, क्या formula है. अगर suppose करो कोई भी employee आपके ऑफिस में HR में आता है और कहता है कि भाई आपने को पेंशन कितनी मिलेगी, if his salary is 15,000 और डिडक्शन भी 15,000 के एक्सरसाइज नहीं किए, तो आप 2 से 14 से उसको ईयर मल्टीप्लाई कर दो, ठीक है ना. 20 साल सर्विस की है, 2 से 14 से 20 साल मल्टीप्लाई कर दो, ठीक है ना. 10 साल की है तो आप 2 से 14 से मल्टीप्लाई कर, 214 multiply by 10 equal to 2,140 rupees per month you will get. But it is a tentative. Some 10-20 रुपए का फर्क हो सकता है, but actually its calculation is correct. Now I made this calculation for all employee, all participant. If your salary 15,000, then 10 year service. This is a 10-year service, and these जो factor है वो you can multiply by number of service. ये 10 years का है टेबल, and that is a 20 years का है. अगर आपने 15,000 पे 10 years सर्विस की है तो you will get 2140. अगर आपने 20 साल सर्विस की है तो 4280 रुपीस आपको मिलेगा. तो ये that is a calculation. Even actually अगर आपकी 55,000 है और 10 years सर्विस की है तो you will get a pension 7860, and you have worked in 20 years, so it means you will get a 15,720. And the second table like this, even जब 1 लाख रुपए आप सर्विस है और आपने 20 साल सर्विस की है, only 20 years, then you will get a 28,571. So what actually this factor has been given by multiply, you can multiply, you can calculate your this pension by this factor. Okay. Next actually, up now, people they are asking, most of the people, even the EPFO, RPFC, they are asking, what is the Mr. your reaction? I say it is a win-win situation. This is the judgment came in favor of the EPFO, also came in favor of department. why I am saying employee won this pension case because RC Gupta case was upheld and reconfirmed. So all employees, they won this case. Okay. EPFO also won this case because GSR 609 was declared as a valid and legal notification. So I say it is a win-win situation, and the advocate also won, both advocate, EPFO and that private sector. So this is a very, very good case, and we have to wait the guideline issued by the EPFO for getting this pension. But if they do not issue a guideline, does not mean that you should not file a option before the 2 week to chale gaye. Abhi tak they have not issued any guideline because 8 week ka time diya hai for adhering the RC Gupta case. 4 month ka aap logon ko time diya hai to get a again option under para 11.3 and 11.4. So I advise to all my participant and employee to communicate to your colleague to file a format which I have designed, and I will supply that format to you. Okay. So again, actually, before coming question answer, I will show you 2 format too. Okay. This format is designed for the retired person. So this format is designed for those who has already retired. You can fill up this form and submit, and don't wait. I am again repeating, don't wait the guideline of the EPFO. Why I am saying? Because there is no direction.
Gupta ji, kindly select the form. It is not visible, sir.
Given by the yes.
Yes. Now it is visible, sir.
Yes. So actually, this is the format. I can say that actually you have to fill this like this. Name of the number, monthly amount, what he's getting, name of the establishment, PF code number, name of the bank, account number, mobile, email, Aadhaar card, and actually he has to declare that whatever the figures are. And again, last, actually, you don't forget this, that if the PF authority failed to consider an calculation of the area along with the interest thereof, then the employee may approach to the Supreme Court. You have to write these things also. Okay. And then actually, if the employer is going to give a certificate, no liability will come upon the employee, because only retired employee, those can be filed this where they have already exercised 11.3 para, means their PF was deducted prior to 2014, actual सैलरी पे उनका PF कटा है. तो इस फॉर्म को एम्प्लॉयर को अगर मोहर लगा के देने में कोई भी लायबिलिटी नहीं आएगी, एक्सेप्ट ओनली क्लरिकल वर्क बढ़ेगा. हो सकता है PF डिपार्टमेंट ये कह दे कि you have to submit the revised return. Okay, that is the only clerical. फाइनेंशियल कोई भी बर्डन नहीं आएगा एम्प्लॉयर पे, आपको ये अपने एम्प्लॉयर को बताना पड़ेगा. तो दिस इज द वन format I am going to, and second format I am going to share another format, that is this one. This format A is only for existing employee, जो कर्मचारी अभी सर्विस में है और हायर पेंशन का बेनिफिट लेना चाहते हैं या उनका एक्चुअल सैलरी पे कट रहा है, क्योंकि ये ऑप्शन का जो टाइम दिया है वो एक्चुअली बेसिकली 4 महीने का है. तो 4 महीने में आप मान के चलिए 15 दिन तो निकल गए, 3.5 महीने बचे हैं. अभी तक कोई गाइडलाइन इशू की नहीं गई है, तो तो मैं तो आप सभी लोगों को I will advise to all our participants. You can advise to other employee also. Okay, you fill this form and submit immediately. If the EPFO does not accept this form, you send by post, by email. Okay, keep it is in some record with you. क्योंकि हो सकता है 4 महीने बाद एक्चुअली वो कहते नहीं विंडो बंद, ठीक है ना? तो I advise kindly exercise this higher pension option immediately. Okay, now actually I am going to stop my this presentation and whatever I have spoke. If anybody is having some question answer, I will try my best to answer it.
Thank you so much, Gupta ji.
Over to Mr.
Yes, thank you so much, SK Gupta ji. It was
Sohail ji.
very informative and practical session. You have very well explained the entire judgment of the Supreme Court on employees pension scheme, and I'm sure that participants has gained a lot of information from this session. There are so many questions are in queue, sir. Before that, I would like to announce all the participants that with the consent of Gupta ji, we will share the format A and B on your email ID, which was shared for the registration. Gupta ji, am I right?
Yes. You can share these all my format to all the participants so they can use and enjoy the higher pension.
Yes, sir. Gupta ji, I'm taking questions from the participants raised on the question and answer window. First question, Anuk R has asked if employees contributing to PF less than 15,000 per month, but employer has restricted employer share on contribution to 15,000. That is 18. More than 15 is getting, and employer has restricted his contribution at 15,000. How can employee opt for pension contribution at actual wages? More than 15,000 is getting and contributing on 15,000.
Yes, very correct. Could I answer, sir?
Yes, sir.
Okay, Mr. Vishal is asking if any employee joined after
Sir, Vishal is second, sir. I have raised the question.
Yes, okay, ऐसा है, I have already made it clear कि
yes, sir.
If any employee is going to join, new employee is going to join on 1st September 2014, whose salary is more than 20,000, as far as me, if he has not worked elsewhere or he was never remained a provident fund member, then that fellow will be treated as an excluded employee first. Okay, and second, actually, he is not entitled either higher pension or the statutory pension.
Exactly.
Again, I am saying, अगर कोई भी नया एम्प्लॉई 1 सितंबर 2014 को 15,000 या उससे ज्यादा सैलरी पे ज्वाइन करता है, तो ना तो उसको ईपीएफ फंड मिलेगा ना पेंशन फंड का हकदार होगा, और अगर उसको प्रोविडेंट फंड जमा करना है तो 26(6) में एक एप्लीकेशन लगानी पड़ेगी, अगर वो एपीएफसी अलाउ भी करता है लेकिन पेंशन का हकदार नहीं होगा.
Exactly. It is almost clear to Anuk R, I think. Now I'm taking second question of Vishal. If any employee joined after September 14 and his wage is 20,000.
इसी का तो मैंने जवाब दिया था सर.
Yes, exactly. Maximum questions are, I think, covered during your session. I'm taking the question of Mr. Prakash Kagajwala. EPS contribution was restricted to statutory wage ceiling as applicable from time to time, that is 5,000 to 15,000, and the contribution was depositing from 400 to 1250 per month as applicable from time to time. Now the member of EPS is since 2004 and retired in the August 2014.
Yes.
Still with the authorities. Now, whether he can opt out the higher pension option or not?
Okay, sir. He cannot. Why I am saying?
Yes.
Because his account number 1 is deducted up to 5,000
Yes.
or 6,500. Okay.
Whatever
And
it is.
simultaneously 417 or 541 is going to deposit account number 10. Okay. So until or unless his employer is going to allow to contribute on higher provident fund, he cannot be allowed or he cannot exercise 11(3). क्योंकि अगर सपोज करो आज वो 11(3) की कोई एप्लीकेशन देता भी है तो कोई भी एम्प्लॉयर बैक डेट से अगर इफ इज गोइंग टू डिपॉजिट द मनी ऑफ दैट एम्प्लॉय तो डैमेजेस और इंटरेस्ट का भी उसको देना पड़ेगा। तो ये एक्चुअली कोई भी एम्प्लॉयर नहीं चाहेगा कि मैं बैक डेट से इसका पेमेंट करूं और ये हायर पेंशन मिल जाए। ठीक है, और ये चीज क्लियर भी की है जजमेंट में। ठीक है सर?
Yes, sir. Thank you. I think Prakash got his answer. Now I'm raising the question of Shiv Prasad Rao. He has raised 3 questions. Existing employees who had not contributed to higher pension before September 14 can contribute, and from which date? So higher pension before September 14.
Yes, very correct. देखिए सर, इसमें आप इशू को इस तरीके से काइंडली अंडरस्टैंड द इशू। Benefit of higher pension can only be given or entitled to those employees who was already contributing the provident fund on actual salary. Okay, so what
Yes.
will happen? Liability will not come upon the employer. Okay, when liability will not come, then employer will sign the option. When you are saying that my provident fund should be deposited on the actual salary from the back date, then again I say liability has to be borne by the employer, 14B and 7Q. That is not advisable. और वैसे भी एक्चुअली प्रोविजन 26(6) में ये लिखा है कि सबसे पहले एम्प्लॉयर की कंसेंट होनी चाहिए। अगर उसकी कंसेंट नहीं है तो आपको नहीं मिलेगा। तो दैट इज नॉट, आई डोंट थिंक they are going to get a higher pension.
Exactly. So majority of questions of Shiv Prasad Rao is covered, I think, with the session, and Gupta ji has very well answered all the queries and clarify the judgment. I'm taking the question of Lalan Chaudhary. Kindly inform the process for getting higher pension for current employee. I think you have shared format A and B for the time being.
Yes. अगर उसका एक्चुअल सैलरी पे डिडक्शन हो रहा है तो हायर पेंशन मिलेगा, नहीं तो नहीं मिल सकता।
हाँ, एग्जैक्टली। सो
आरती गुप्ता के केस में क्लियर डायरेक्शन है कि आप अकाउंट नंबर को ट्रांसफर करके एडजस्ट कर सकते हैं। मींस आपका अकाउंट नंबर 1 में जो पैसा जमा होता था वो एक्चुअली 10 में ट्रांसफर हो जाएगा।
Exactly, sir. So there are so many questions. I have 40 plus questions. If a person is retired after 2014, what they need to do? Amit Patil is asking.
Yes. Actually, वैसे मैंने इसको क्लियर कर दिया है. I want to again clear. If a person retired before 2014, there is a 2 direction given by the Supreme Court. If he has opted 11(3), he is entitled to get the pension. If he has not opted 11(3), he is not entitled.
Exactly.
और अगर आपको ये पढ़ना है तो एक्चुअली ये बिल्कुल क्लियरली जजमेंट में पढ़ लो, बहुत क्लियरली लिखा हुआ है। ठीक है, मैंने अपने प्रेजेंटेशन में भी जो मैंने पैरा बनाया है, दैट इज ए डायरेक्शन नंबर 2 और 3 है। ठीक है,
एग्जैक्टली। सो गौरव उपाध्याय इज आस्किंग इफ वी वांट टू गो फॉर हायर पेंशन, the difference amount will be henceforth or bifurcated from PF balance of employees or what?
ठीक है जी, एम्प्लॉय को एक्चुअली में इसमें पैसा दे आर नॉट गोइंग टू एक्सेप्ट बिकॉज एक्चुअली ऑल द लायबिलिटी विल कम अपॉन द एम्प्लॉयर। ठीक है, बिकॉज एम्प्लॉयर इज गोइंग टू जनरेट द चालान। एम आई राइट सर?
Yes sir.
और ही इज गोइंग टू डिपॉजिट द मनी and under that code all things is going to deposit. So what will happen के liable जो damages का और उसका interest का कौन देने का हकदार होगा? एम्प्लॉय तो नहीं देगा।
Exactly.
तो केवल एक्चुअली ये स्कीम उनको फायदा है जिनका एक्चुअल सैलरी पे अपनी डेट ऑफ ज्वाइनिंग से कट रहा था और वो ऑप्शन नहीं दे पाए थे किसी कारणवश, उनको ये अपॉर्चुनिटी अवेलेबल है, क्योंकि इससे ना तो एम्प्लॉय पे लायबिलिटी, केवल एम्प्लॉय पे लायबिलिटी आ सकती है, कौन सी आएगी, 1.16% की ओवर एंड अबव, क्योंकि 6 महीने के लिए सस्पेंड कर दिया है वो प्रोविजन। ठीक है,
Thank you much. GM Saini is asking, an employee getting salary more than 15,000 but did not pay PF and pension on more than 15,000. Can such person now opt for higher
No.
pension? Not
No.
at all. I think.
no, not at all.
Who is more than 15,000? They are only eligible. Yes, yes, yes. So Srinivas is thanking you, sir. He is expressing thanking words for you. Moving to the next question of Ramesh Chand Gupta. Service was 1991 to 2020, but from 2006 to November 2012 was on ceiling amount from employer, but employee share was on full basic. Can he apply?
Which question, sir?
Employee share was on full basic.
No, which question you are reading?
Ramesh Chand Gupta, sir.
Ramesh Chand Gupta. That
at 5:30 p.m. Yes.
5:30 p.m. Okay.
He is also RC Gupta, I think.
RC Gupta. 5:30. अच्छा.
Yes, 5:30. Ramesh Chand Gupta.
Yeah, yes, correct. Now I got that question. He's asking, my service was 91 to 2020, but September 2006 to November was on ceiling amount from employer. Can they re-exercise the option to higher pension? The problem, Mr. Gupta, will come because actually your provident fund as per your version was deducted 91 2020, but 27 was on ceiling limit. No, actually, I don't think your case can be considered because your PF was deducted 2006 to 2005 on ceiling limit. Okay. Ab suppose karo, if you are going to opt the option, so then PF authority will say, okay, you deposit the balance amount from 2006 to 2012 along with the interest, along with the damages, along with everything. Then employer is not going to sign your option, and you have no right to directly say any court of law without the consent of the employer, because all employee is only entitled to get the provident fund up to the statutory limit, and above the statutory limit, it is only option is available with the employer. If employer doesn't want, you can't force employer. Okay.
Thank you, sir. Harpreet Singh is asking, after judgment, whether existing employees who are contributing on rupees 15,000 after joining September 14 can opt out or not?
Yes, 100%.
Yes.
बस केवल एक प्रिंसिपल है, अगर उनका एक्चुअल पे कट रहा है तो.
Exactly. So Prakash Mahadik is asking, I have a question, if any employee joining in year 2007 and contributing till 2011, and further he contributes on rupees 25,000 since 2011 till date, will he be eligible for higher pension? I think yes.
Who has asked
he is contributing? Prakash Mahadik, he is contributing.
This time by time guy?
5:32. Prakash Mahadik.
Oh yes, I got I have a question. If any employee joining in 2007 and contributing till 2%, you have to submit this. Why I am saying, the 2007 mein this scheme was available. Okay, and contributing up to 2011, and further he has contributed 25.
I think Guptaji's connection is disconnected, I think.
Actually, was
Yeah,
video was, there's no problem. Video was no problem. You speak, right?
yes, yes, your video is off, sir.
Video.
Oh.
Video actually that it is not you can video because the hostage stop it.
Okay, right, sir. Please check, sir.
Done now. Okay, thank you.
So, Vishal is
My
asking.
presentation, most of the question has been given an answer, but I'm ready to give every question of the all participants. Thank you, sir.
Yes, it is difficult. I think you have very well covered all the questions. If any question is still pending, we can take it over mail also, sir. So are you allowing me to start more to get more questions, sir? Gupta ji.
Yes, I have no problem, sir. You can continue. I am ready to give answer to every person. Okay, sir?
Or you can take questions from your end also, sir, because there are so many questions.
Right. ये क्वेश्चन ये जो एक्चुअली दैट इज गिवन बाय 5:40 PM, दैट इज important, so I am going to give an answer. Okay. ये है कथक राव के, that 5:44. For some time my PF on 6,500 for 5 years and 2,000 onward full wages. I am eligible for higher pension. Yes, but you are eligible higher pension from 2009. Prior to 2009, you are not entitled, because actually there is no cutoff date to opt the higher pension before 2014, which has been opportunity has been given to you for opting. So your higher pension will be calculated from 2009 onward. Okay.
Thank you, sir.
Any live question? If anybody is interested, he can ask.
Prior to your question, sir.
I say actually you can share my this format to everyone. Okay.
Yes, sir.
So they will get opportunity. So sir, we can continue or we can.
Gupta ji, I'll share your both formats to the participants.
Yes, kindly do that.
I think majority of questions have been covered in your lecture.
Right, sir.
And if any question which is not covered or not addressed, That shall be taken over the mail, sir.
Over and above, actually, if anybody is interested to Hindi version of the judgment, I am also having that copy with me.
Okay, okay. So
If
Gupta ji,
requirement is, I am making an announcement that if any participant needs the Hindi version of the Supreme Court judgment, that translation is done by the Supreme Court and it is available to all. If somebody is asking, I will forward that Hindi version to Mr. Sohail ji, and you can send that requirement to Mr. Sohail. You can forward that Hindi version to all employees, all participants. Okay, sir?
thank you, Gupta ji. So with this, we are moving towards the vote of thanks, and therefore I would like to invite Kashyap Rais to deliver the vote of thanks.
Good evening, everyone. I consider it's an honor to present the vote of thanks for the webinar on the recent Supreme Court decision of Employees Pension Scheme. Let me begin by thanking the Almighty Allah for making session one a spectacular success. On behalf of the Savani Institute, first and foremost, I express my heartfelt gratitude to our guests from government authorities, industrial associations and consultant fraternities for sparing time to grace the occasion. I also express my heartfelt gratitude to our keynote speaker, Advocate S.K. Gupta, for excellent practical sessions on subject matter. Sir, I want to thank you for generosity and continued support. I would also like to convey my heartfelt gratitude to all of the participants for the excellent contributions. I hope everyone has learned something new about the pension judgment. I'm very grateful to the Savani Institute team and all individuals who have worked hard both directly and indirectly to ensure the success of this session. I'd like to thank you all again for your time. I hope to meet you all at the future sessions on labor codes and ESI PF web portal training for your executive system. Thank you very much.
Thank you, Gupta ji. Thank you so much. Thank you, Kashyap.
Welcome.